She walked in carrying a legal pad. I want you to hold that image for a moment before I tell you anything else. Not the courtroom, not the complaint, not the two teenagers who were sitting at the defense table with their parents, with the careful posture of young people who had been told by every adult they trusted to be respectful and quiet and patient, while a room full of strangers decided whether they were allowed to use their own street. Just the legal pad, the neat handwriting, the numbered list, the particular certainty of a person who has organized her grievances into bullet points and arrived at a federal courthouse expecting the institution to read them and agree. What does power do when it meets a consequence? What does it say? I have been in that room, behind that bench, for 26 years. I have seen a great many things that required testimony. What happened in that courtroom on a Tuesday morning is something I have thought about since. Not because of how it ended, but because of what it revealed about a belief so complete it had never once considered the possibility of the question I was about to ask. My name is Victor Lawson. I was the judge in that room. If what I just described is something you have seen, in a different room, in a different form, subscribe and hit the bell. This channel is something honest to return to. And before we go in, write the one thing from this case you are going to stop pretending is acceptable. One thing. I will read it. What the record shows is more specific than what any summary would tell you. She walked in ahead of her attorney. That detail matters. In 32 years on the federal bench, and before that, 6 years teaching people who would go on to sit where I sat, I have learned to read a room from the moment the doors open. Not because I am looking for something to confirm, because the room, before anyone has said a single word on the record, is already telling you everything. And what this room told me in the first 4 seconds of that Tuesday morning was that the woman who had filed this complaint believed she was about to receive something she was owed. She walked in ahead of her attorney. She did not look at the defense table, where two teenagers, 17 and 15 years old, accompanied by their parents, sat with the careful posture of young people who have been told by every adult in their orbit to sit up straight and say yes, sir, and no, ma'am, and do not, under any circumstances, speak unless you are spoken to. She did not look at them. She looked at me, not with deference. Not with the particular quality of attention that most people bring to a federal courtroom when they are there for the first time, and the weight of the institution has settled on them in a way they did not fully anticipate. She looked at me the way a person looks at the final obstacle between themselves and something they have already decided belongs to them. There was a legal pad on the plaintiff's table. She had written on it in a careful hand. I could see it from the bench, the lines of text organized into what appeared to be a numbered list. She set it down with a small, precise motion. She smoothed the front of her jacket. She sat. I have spent a long time thinking about that moment, not because it was extraordinary, because it was so completely ordinary. Ordinary in the specific way that a certain kind of certainty is ordinary, the kind that has never been interrupted, that has moved through the world collecting confirmations of itself and shedding every contradiction the way water sheds off a surface that has no place for it to go. I want to name what I was looking at before I tell you what happened in that room. Because if I skip to the complaint and the ruling and the moment she understood what the law was actually going to do, you will miss the thing that made this case worth narrating. What I was looking at was not malice. I want to be precise about that. What I was looking at was something older and in some ways more durable than malice. The unexamined conviction that one's own comfort constitutes a legal right. That the space around a person, the neighborhood they live in, the street in front of their house, the particular quality of quiet they prefer on a Saturday afternoon, belongs to them in a way that the law is obligated to protect. I had seen this before. Not this person, but this certainty. The certainty of someone who has spent decades having their preferences treated as requirements by the people around them, and who has arrived in a courtroom expecting the institution to do what everyone else has always done: accommodate. What I had not yet told her, and what the next 2 hours would clarify beyond any possibility of further misunderstanding, was that I am not in the business of accommodation. I am in the business of the law. The specific detail that had reached me before the proceedings began, through the pretrial briefing I had reviewed the previous afternoon in my chambers, was this. The street in question was a public street, not a shared private lane, not a homeowners association pathway with a recorded easement. A public street, maintained by the city, open by law to any member of the public for any lawful purpose. The teenagers had been skateboarding on it. They had been skateboarding on it on weekend afternoons for approximately 4 months, in the stretch of sidewalk and street directly in front of or near the plaintiff's residence. They had not damaged her property. They had not threatened her. They had not trespassed. They had made noise. They had, on at least one occasion, according to the plaintiff's own complaint, performed what she described as a dangerous trick that made her afraid for their safety. And she had come to my courtroom to make it stop. What happened over the next 2 hours is something I want to show you carefully. Not because the outcome was in doubt. By the time I had finished reading her complaint, the outcome was not in doubt. But because the path to that outcome revealed something about a particular kind of belief that I have spent my career watching operate in the world, and about what happens when that belief encounters an institution that is not designed to validate it. She had been waiting for someone with authority to agree with her. She had come to the wrong room. The complaint as filed ran to 11 pages. 11 pages is not unusual for a civil complaint. I have read complaints of 200 pages that made their point in the first 15. But 11 pages for this particular set of facts was instructive in the way that excess is always instructive. It told me that the plaintiff understood at some level that the facts alone were not going to carry the weight she needed them to carry. So she had added language. She had described in considerable detail the disruption to her daily life, the noise on Tuesday afternoons, the visual intrusion of young people she did not know moving through a space she had come to regard as, and I am quoting directly from the complaint here, her functional private extension, not her property, her functional private extension. I read that phrase 3 times. What I understood reading it was not that this woman was confused about the law, though she was. What I understood was that she was not confused about what she wanted. She wanted a courtroom to ratify something she had already decided was true, that her relationship to the space around her home was qualitatively different from other people's relationship to that same space. That her years of residence, her investment in the neighborhood, her particular sensibility about noise and movement, and the specific visual character of her street had created something the law ought to recognize, even if it had not yet gotten around to naming it. It had not, and it was not going to. The first moment I want you to stay with happened approximately 20 minutes into the proceeding, after I had allowed her to make her opening statement, which she delivered largely from the legal pad, reading with the careful emphasis of someone who has practiced the reading, who has heard it in her head enough times that she has begun to mistake the rehearsal for the event itself. When she finished, I asked her a question. I asked it quietly because in my experience, the quiet question carries more than the loud one. I said, "What statute are you proceeding under?" She looked up from the legal pad. I want to describe that look precisely because it is the most important thing I observed in that entire proceeding. It was not confusion. It was the particular expression that appears on a person's face when they encounter a question they did not know could be asked, not because they are unintelligent, but because no one in their experience has ever required them to justify, in specific technical terms, the framework within which they are making a demand. She had come to this room with a grievance that felt, to her, so self-evidently legitimate that the mechanism of the law was a detail, a formality, something her attorney would handle while she explained how the situation had affected her. Her attorney at that moment was looking at a point somewhere between his client and the ceiling. She said, "I'm sorry?" I repeated the question. I said, "I'm asking what statute you believe gives you the right to the relief you're seeking. What law are you proceeding under that would allow this court to prohibit these teenagers from using a public street?" There was a pause. It was not a brief pause. It was the kind of pause that fills a room and changes the temperature of it. She said, "The noise ordinance." I told her the noise ordinance was a municipal code provision enforced by the city, not a basis for private civil action in this court. I told her that even if we were in a court of appropriate jurisdiction for a noise ordinance claim, which we were not, she would need to demonstrate that the sound levels exceeded the ordinance threshold and that her complaint contained no decibel measurements, no citations from the ordinance, and no evidence of any formal complaint made to the city prior to this filing. She said, "I shouldn't have to measure it. It's obviously too loud." I have heard many things said in my courtroom in 32 years. I want to tell you that sentence has stayed with me, not because of its content. The content was what I expected, because of its structure. She said I shouldn't have to measure it, meaning the requirement to establish a fact before asserting it as a fact should not, in her case, apply. Meaning, her perception was not evidence to be weighed, it was a conclusion to be accepted. I did not raise my voice. I never do. I told her that the function of this court was to evaluate evidence, that her perception, while potentially sincere, was not evidence that could be adjudicated, and that without a cognizable legal claim supported by applicable law and factual predicate, There was no relief this court could provide. She looked at her attorney. Her attorney looked at the table. I watched him in that moment and I thought, he knows. He has known since the day she walked into his office with that legal pad. But she is a client who believes what she believes. And a client who believes what she believes with her particular intensity is not easily redirected. So he filed it. He dressed it in 11 pages of language. He hoped something would emerge in the proceeding that would give the case traction. Nothing emerged, because nothing was there. What I understood in that pause, her looking at him looking at the table, was not new. I have watched the moment of disconnection arrive in many proceedings. The moment when a plaintiff understands, for the first time, that the narrative they have been carrying, the narrative that felt so solid and so legible from the inside, has just encountered a surface it cannot pass through. What was specific to her was the shape of it, because the thing she had believed was not merely that she was right. She had believed that being right, her version of right, the version that lived in the legal pad with the numbered list, was sufficient. That the institution would see what she saw, feel what she felt, and act accordingly. The institution, in the form of the law, did not. There is a third thing I want you to understand about this case, because it is the thing the summary would leave out. It is the thing I have returned to in the months since this proceeding closed. Not with any particular anger. Anger is not a register I find useful, but with the particular kind of consideration that cases like this one earn. During a brief recess I had called to allow her attorney to confer with his client, I stepped into the corridor and passed, by chance, the room where the two families, the teenagers and their parents, were waiting. The door was open. I did not stop. I was not supposed to be in that conversation, but I heard enough in the 3 seconds it took me to pass to understand what was in that room. The 15-year-old was asking his father if they had done something wrong. His father was telling him no. The 17-year-old was not asking anything. She was sitting with her hands flat on the table, very still, in the posture of a young person who has learned too early that the world sometimes requires you to sit still and wait for someone else to tell you whether you are allowed to exist in it. I have spent 32 years in courtrooms. I have presided over cases involving vast sums of money, over cases involving violence, over cases involving institutional failures that took decades to produce their damage. I want to tell you that the image of that 17-year-old sitting with her hands flat on a table, waiting to find out whether she was going to be prohibited from skating on her own street, is an image that has not left me. Not because it is the worst thing I have seen, because of its smallness, because of the specific indignity of having to appear in a federal proceeding to establish your right to exist in a public space that the law has never for a single moment suggested you could not occupy. That is what the complaint was really asking me to do, not to resolve a dispute. To validate a belief that these teenagers, by their presence, by their noise, by the particular way they move through the world at 15 and 17, were subject to someone else's right to remove them. They were not. I returned to the bench. I looked at the plaintiff. I looked at her carefully, the way I look at everyone in that room when I am about to deliver a ruling, because I believe the person receiving a decision is owed the full attention of the person making it. And I said, this court is dismissing this complaint with prejudice. There is no cognizable legal claim before me. The defendants were using a public street for a lawful purpose. Private discomfort, however sincerely felt, does not constitute a legal injury. This court has no basis and no authority to prohibit any member of the public from using a public street for a lawful purpose, regardless of the preferences of the person who lives nearest to it. The complaint is dismissed. That is what she did not expect. Not the dismissal itself. Some part of her, I think, had begun to understand during the recess that the proceeding was not going where she had planned. What she did not expect was the absence of any softening, the absence of any acknowledgement that her feelings, while legally insufficient, were at least understandable. The absence of the particular tone that institutions sometimes adopt when they are declining a request from someone who is accustomed to having requests granted. The apologetic register. The here is what we can do instead. There was none of that, because there was nothing to soften and nothing to offer instead. The law is the law. The street is the street. The teenagers were doing nothing wrong. Simple, and in its simplicity, complete. I have thought about this case in the months since in a particular way that I want to name honestly. I said at the start of this narration that what I was looking at was not malice. I stand by that. I do not believe she meant those teenagers harm in the way that harm is usually meant. I believe she had constructed over many years a relationship to her neighborhood that had gradually expanded to include the belief that the character of that neighborhood, its sounds, its rhythms, its particular quality of Saturday afternoons, was something she had a proprietary stake in. And at some point, without her noticing, that belief had become so complete that the teenagers on the street were not, to her, people exercising a right. They were an interruption. What I want to say, for the record, and for everyone watching this, they had the right. Not the right I gave them. They did not need my permission, and I did not give it. The right was already there, in the law, in the nature of a public street, in the basic proposition that public space belongs to the public. What I gave them in that dismissal was the confirmation that a room with authority had looked at the facts and found what any reasonable reading of the law requires: that their presence on that street was lawful, that their noise was lawful, that their youth and their boards and their weekend afternoons were not subject to removal at the request of a neighbor who had come to believe that her comfort was a legal right. That is what I said in that room. I will say it here too, because it deserves to exist somewhere that is not a case file in a dismissed proceeding. You were allowed to be there. You were always allowed to be there. You did nothing wrong. I want to ask you something before I go. Write your answer in the comments, because I read them and because what you write will tell me something I cannot learn from the cases themselves. Write the thing from this case you are going to stop pretending is acceptable. One thing, not a system, not an abstraction. One specific thing, a behavior you have witnessed, a demand you have watched someone make, a moment when someone's certainty about what they deserved required something from you or from someone near you, that this case is making you want to stop walking past. Write it. One thing. Make it specific. I will be here. If what I described today felt like something you have been waiting to hear someone say out loud, I am glad you found this channel. Subscribe. Hit the bell. What I bring here is the same thing I brought to that bench every morning for 32 years. The record as I saw it, with nothing softened and nothing added. I do not know who is watching this. I know why I made it. Those teenagers went home that Tuesday and skated on their street. I am certain of this because it is what the law allows, and because it is what 17-year-olds do when a Tuesday afternoon is still available to them. That is all I needed to know. That is the only confirmation a dismissal requires.